freed YouTuber Lane Myers
unjustly imprisoned
continued to confuse fans with his attempts to comply with court orders.
He is exercising his right to not implicate himself in victimizing somebody who is not a victim.
To take down videos on Friday, as some of the videos he had been ordered to take down apparently remain at delisted status.
Sounds like a trick to me. Okay, I'm just gonna let this guy go and then I'll do my thing.
And are freely available to anyone with a link. Myers had been jailed since March on charges of stalking and harassing the wife of a Tucson city prosecutor. He accepted a plea deal in June to admit guilt for a single charge of felony harassment and a single charge of felony stalking. The YouTuber had faced two sets of charges, one for violating a protective order that was granted to protect the victim of his crimes, and a second batch that he picked up immediately after he was released on bond for violating the terms and conditions of his bond.
The same ridiculously loosely described conditions.
He would later argue that he was under the impression that the release conditions hadn't started because he hadn't received a printed minute order from the hearing.
And the fact that the judge said take down all the videos of the victim when there is no victim because there's been no conviction. So, what do?
Effectively stating that even though he had been released, the conditions should have applied until the order was printed. This argument was rejected multiple times by the court. After release this week, Myers is apparently playing on the court's own lack of specifics, as the court did not specify which videos should come down or what constituted a removal. The handwritten instructions in his supervised probation conditions state the following, quote, remove all videos from streaming services, YouTube, or social media that mention the victim or her family, including identifying information.
Well, he's never posted identifying information about them. Start quote.
As Myers had previously shown, he will only comply with specific orders from the court. When he was released on the first set of charges in March, he immediately complained that he had no list of videos to remove from the prosecution, so he was unable to comply with their wishes.
Well, if you don't tell somebody what you wish, how can you comply?
Prosecutor Rachel Stiles, again, did not list what videos should come down in his probation order or how they should be removed.
Yes, she is still playing I Know What You Did Last Summer, right? And Mr. Myers is supposed to be like, oh, take down this video of the victim? I mean, the Shannon? Come on.
This is a rare blunder for the prosecutor after stating that Myers would attempt to test the system every way he could.
Ha 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 ha. Good job trying to cover it up, buddy. We know it's not a blunder. Their only way to get him back in court and try to legitimize what they're doing.
In a statement at his sentencing hearing. While the order, remove all videos from streaming services, YouTube, and social media, is clear to most, Myers can argue again without a specific list. He's guessing as to what videos need to be taken down. He's doing his best to comply with the order.
I just want to say that first part is a fact, not an argument. The second part about doing the best, yeah, that's bullshit, but...
He can also argue what the word remove means. YouTube has 3 ways to remove videos: deletion, delisting, and making a video private. All 3 actions remove the video from public listings, but access can still be granted to a limited audience.
I mean, that is a multifaceted word. For example, you can be removed from a courtroom, but that same police officer can also remove you from planet Earth. So, I mean, you know, Where you draw the line, buddy? Maybe there needs to be some discussion on that, buddy boy. Oh, and don't go thinking that was any kind of shot. I'm just saying that remove could mean legally some different things, all right?
Without a specific order to delete the videos, Myers has shown that he will test the limitations of his release conditions. It's unclear where his victim or others can go for clarification of the terms of Myers' release, or what can be done about the videos that remain live on YouTube and accessible even though they've been delisted.
All videos remain live on YouTube until they're deleted. So, what's your point?
As part of his probation conditions, Myers was ordered to give full access to his YouTube channel to his probation officer.
Everybody has full access to his YouTube channel, unless you want to stand in the room next to him while he's taking bong rips and dancing around with hammers.
It is unclear if that officer is trained in social media and YouTube and is aware of the different levels of removal from the service. The issue may end up back in court as Myers continues to push the boundaries.
See, I don't see how somebody could listen to this and then hear what he just said and then think that it means anything. He just spent 2 minutes explaining how the prosecution and the probation will not set boundaries, right? They just basically said, hey, don't do that shit again, bro. Take the shit down. Literally, that's what they said. He's not pushing any limits or boundaries. He literally has none. He has a vague description of what they kind of want.
Myers' legal defense Give and Go campaign stalled on Saturday with no new donations recorded. The crowdsourcing title was won by our own ongoing expenses campaign, which took in $100, followed by Sean Paul Long Island Audit Reyes, who took in $50.
Mac. Now who's trying to profit off of somebody's misery, buddy? Because check this out. There's over $48,000 already budgeted for bullshit like this and fake victims. And real ones, I'm sure. To get their life back on track after harm has occurred. Harm. Seriously, harm. Or are you just trying to raise money for the live streams that you just get on and just laugh at people's misery? Is that what you're trying to fund?
To his Support the Fight Against Tyranny and Corruption campaign. As of Sunday afternoon, the 2 videos we had as examples in a previous article had changed from unlisted status to private status. While they have not been removed from YouTube, public access has indeed been removed from each video. 2 more videos have been provided by members of our Discord forum that apparently mention the victim are still available on YouTube. A video labeled The Resurrection uses his victim's face in the thumbnail and is freely available on his YouTube channel.
So, I actually unlisted my videos because I talked to somebody who had a little more insight than I did, and I actually somewhat agree with, well, I do agree with his take on it. And if we don't need to continue to victimize somebody who is a victim, I don't think she is, but I don't think it needs to be that way, right? So I did what I did. Because, yeah, there's parts in there where I said stuff that were just to be, you know what I mean, Lane Myers-y. And I don't think we all have to cross that line, you know what I mean? I don't think it's, whatever, it doesn't matter what I think. But, so anyways, so I did that, I don't want to say out of respect, but out of a possibility of disrespect. Also, it distracts from what's really going on, you know what I mean? Just talking shit about her as opposed to, you know, showing her many lies and corrupt everything. If Mr. Myers is guilty of these crimes, she doesn't need to lie. She doesn't need to cut corners and use dirty tactics. And if he is right, then we don't need to do the same to her. You know what I mean? That's all. That's all I'm going to say about that. I'm sorry, Rachel and Doug. I mean, you're the prosecutor and the judge. I mean, you guys are just going to get it either way. You already know the deal. You know what I'm saying? So sorry. And Matt, I'm sorry, buddy. I mean, you're a douchebag, bro.
While a video titled Law Lessons with Lane Myers has been delisted, we will monitor both videos and provide updates as we receive them.
I'm just going to start with what, and these are going to be unofficial subjects, right? But for people who have been following this, and some of this may be my ignorance or whatever, I'm not a lawyer. So, anyways, I'm going to start with my subjects. So let's not forget that in December of 2024, Judge Lewinsky is the one who confused all the court goons about recording in a courtroom, because literally it says use of a recording device in a courtroom prohibits the use of a recording device in a courtroom. That's hilarious. Thereby making everything Lane Myers did from September to December not whatever, right? And she lovingly added this at the very end. You could be charged with harassment. 2921A 2-4 or whatever. So remember, Lewinsky is the one who did that. So you have to have that as a back to kind of understand my question here. Okay, so here's when the prosecutor, county attorney thought that she became the victim because they mailed her the victim's rights form, right? And I know some of you were like, it's the police department. But when did they really believe it? Could it be that October 10th after their little APAC meeting? I mean, we all know how it is to be reunited with our high school and college friends. We just get together and tell a bunch of lies to each other. Same thing the attorneys do. And somehow a recording with 33 lies came out of this. Interesting, yes. Now, is that when they truly believed it? Because this is what it says when you get served. It says you allegedly have committed a series of acts. But just like it said after the Arizona prosecuting attorneys huddle, yes, this one, the one that Shannon Walker is your go-to information for the 2025 prosecuting attorneys workshop, whatever they want to call it. The 3-day prosecutor academy. That's your contact right there, Shannon A. Walker. So here's where the problem is. For the most part, they don't represent the victim or law enforcement. Bullshit. Well, here's the county budget, right? So it looks to me like the county attorney, aka the prosecutor, criminal prosecution, and the victim services are under the same person, right? Weird. Now it says all city officials, or all city elected officials, all city employees, and all members of the BCC shall comply with the laws regarding all actual or potential conflicts of interest and shall not use their official positions to influence government decisions in which they have material financial interest or where they have a duty or responsibility or personal relationship that may give the appearance of a conflict of interest. So no mention of a conflict of interest whenever Matt filed the mental competency motion. Nothing mentioned on the 2 recorded petitions for the injunction against harassment when Matt was sitting there both times, beginning to end. The APAC get-togethers where Matt charges $50 or whatever, which is the whole reason Mr. Myers was so frustrated about the whole thing, was because he was withholding the disclosure, whatever. Come to find out, she is the one who organizes these Arizona prosecuting attorneys to get together through her college. Also,
to tell you what you need to do.
I'm requesting to modify Mr. Myers' conditions of release accordingly. Number 2, Mr. Myers needs to be directed not to have any direct contact with judges, court staff, city prosecutor staff, or other city employees. If he wants to do something on a case.
Where's the notice of the conflict of interest there? She is a whatever. She works literally at the College of Law library, the law library.
Hypothesizing why it took this long, or did something like, because like if what you say is true, it's the mayor and the council. Well, it was the mayor and the council since I got arrested. And what you're saying is now that's why I wanted to question you directly, because I'm going, well, Matt, if it's a conflict with the city and the mayor, then why didn't you bring that up as soon as you saw the case and say, hey, we can't take this case? And I see why now, because you're saying it's not a standing like thing over there. There's not a standing policy to
my knowledge.
Right. That's what I'm saying. So it wasn't like, a default thing where like, it's the mayor and council, conflict of interest, no object, we don't even discuss for it to get to this point, and it leaves like, okay, the door open for questioning, like, what took so long?
And I don't know. So real quick, sir, I think this has been a pretty productive conversation.
Yeah, for sure.
But I do have another commitment.
It's all good.
I do have something else I got to do here in a few minutes. So you're free to send me any email you want to send me.
I will.
Don't worry about blowing up my email.
No, but you know what I'm saying?
I understand we're in an adversary relationship.
It's all good though. This is
you know,
business, bro. This is business. I went to the meeting to get arrested on purpose. This is business. This is bigger than, I'm trying to set case law. Like, it's not me versus Matt Walker. I'm telling you.
Okay. I agree with that. So feel free to send me any email you want, and, once I get more information, I'll share it. Okay?
Yep. I appreciate it. Have a good one, man.
Okay.
Thank you.
You too.
All right, bye.
Included time. When you file a motion to continue, section.
I did not file. This is the bullshit, sir. There's no fucking motion filed by me to continue, and that's the bullshit Cranshaw tried to pull. The last judge tried to pull. I did not file it, give or take, you know what I'm saying? And the whole motion, the victim, right. I can file, dismiss, dispositive, all that. I have that access with Judge Mayhew regarding the whole, is Mackenzie, all that. But I'm talking about the one with the city council. I can't object because the case is no longer there.
Well, yeah, I don't entirely disagree with you. You can either try to file something in city court, or once you get something from justice court, you are entitled to file another motion articulating your position. Okay?
But you can just argue that it wasn't filed within 14 days. Like, if I want to object to something at that hearing, I have 14 days to do it.
So I'm not, listen, sir, you can have whatever opinion of me you want to have. I'm not going to trick you, okay? So if you want to file something that says you're objecting or whatever, I'm probably not going to take, if it's strictly to move the venue or to change venue, or you're saying that it was going to properly move to justice court, I don't know that I'm going to take a position on that. Quite frankly, I don't know that I really care.
Oh, I'm not objecting. I'm not objecting that. I don't care if it was moved. Here's my primary concern, that this piece of paper says that I asked for the continuance and that it stopped my time. I don't care if they move it to justice court. My only concern is if they move it to justice court, you're still the prosecutor, and I don't care if they move it there. I don't object to that. I would object if they change prosecutors and then all the evidence I gave you just disappears. But I would in the moving it from Judge Cranshaw to Judge Mayhew, I don't object to that. I do object to them not having the trial on September 30th and somehow pinning it on me like I asked to do that. I didn't do that.
Sure. So you can, wherever the case lands, okay, if it's the one in front of Mayhew or whatever, we can make a record. You're free to email me.
I know. I know, but I don't want to blow you up, dude.
You're free to email me.
I don't want to blow you up. I know.
Look, this is my job.
I know, but I can get emotional sometimes and send frivolous emails, and I'm trying to save it for productive emails. You get what I'm saying? And I was getting some productive emails ready, and then I got hit with this.
To do that without that sort of...
Okay, I understand.
I hope it doesn't happen, but if it does happen, feel free to come back and ask for a modification.
Okay, thank you, Ma'am.
Anything else that you want to do? Any other findings that you think I should be making if we...
Now, to answer my own question, this is the hearing where everybody, all the legal people in Pima, all decided, all the Apex, everybody decided that Lane Myers has victimized her, right? It is.
Anticipate the appellate court is wondering what I did and why?
Well, that's an odd question. Well, I'm going to switch gears for a second now. Okay, once again, this is for the people who might have a higher thinking level. Okay, I realize that this is not a case that's in the same state, that's even in the same whatever, you know what I'm saying? And I realize that it's a divorce case, and I get all that. It's the idea of what he's saying and what happened, which I'm going to explain is, I think, the court covering up for some bullshit, which I'm going to explain, right? So just hear this out first, and then let me explain. Okay, listen to this. Griffin, at the contested hearing on the injunction, Myers never had any legitimate reason to contact Shannon, although she works at a law school. Okay. He respectively contacted her in order to intimidate Matt out of prosecuting the Tucson City court cases when we heard him on the phone say that he only wants Matt to be the prosecutor because it got switched courts. And anyways, so this is just all Matt saying, oh, you know what I mean? These are my reasons that Judge Griffin said all this stuff, right? And the reason is because of what you're going to hear here. And just real quick, it just kind of mentions that he was served and then he broke the whatever. They're flip-flopping the two. A judge said, if you want Sergeant Hill to stop calling you, then come down and serve yourself. That's how that happened. But anyways, listen to this.
Decree of divorce. The wife filed a petition to reopen the case and set aside the final judgment, arguing that service by publication was improper. So at its very, very most simple terms, the case started out because man files to divorce his wife, and instead of serving her personally with a summons and complaint, they served her by publication. They published notices that she was expected to see somehow. And that would work back in the old days. You go down to the town square and you publish a notice, hey, so-and-so is suing so-and-so. Word would get around in the community and, hey, you're being sued. Oh, I guess I better go read that notice. But publication these days doesn't exactly get the right people. So the trial court denied the wife's motion to set aside the divorce decree, and they used an order, the trial court used an order that relied upon non-existent case law. For the reasons we discussed below, we vacate the order and remand for the trial court to hold a new hearing on the wife's petition. We also levy a frivolous motion penalty against the attorney for the husband. And now, some people have already caught something. A lower court made a mistake because the lower court also relied upon bad case law. And so when an attorney submits bad case law to a court, the court should have somebody checking the case law to make sure it makes sense, especially if it's cases they're not familiar with, which it would be because they were invented by AI. But according to the wife's October 2023 verified petition to open the case, husband filed a complaint for divorce in April of 22. Service was performed by publication, and the trial court entered a final judgment in July of 2022. In the petition, wife argued that she had moved to Texas after they had separated, and that husband failed to use reasonable diligence to figure out where she was. Instead, they notified her by publication. Following a hearing, the Supreme Court denied wife's motion, and here the Court of Appeals has granted the wife's application for discretionary review, and the appeal followed. Now, the wife argues, and she cites a case, that the Superior Court made a mistake when it denied her petition to reopen the case and set aside the divorce decree because husband did not make a sufficient showing of due diligence to allow service by publication under the Georgia statutes. Wife points out in her brief that the trial court also relied on two fictitious cases in its order denying her petition, and she argues that the order is therefore void on its face. Now, in the husband's brief, which is filed by his attorney, it doesn't address the wife's assertion that the order relied on bogus case law. But his attorney relies instead on 4 cases, 2 of which appear to be fictitious, and the other 2 have nothing to do with the proposition stated in the brief. And I know many attorneys who've toyed with these things. A very good friend of mine said he asked one of these programs to draft him a brief. And he goes, it's the most beautifully written thing I've ever seen. And he goes, then I started looking at the cases, and it turns out that half the cases didn't exist, and half the cases that did exist didn't say what they're alleged to have said in the brief. So it creates all this meaningless stuff. So undeterred by wife's argument that the order is void in its face because it relies on non-existent cases, husband cites 11 additional citations in response that are either hallucinated or have nothing to do with the propositions for which they're cited. The brief further adds insult to injury by requesting attorney fees on appeal and supports the request with a hallucinated case. So, yeah, that's not good. So the court says we are troubled by the citation of bogus cases in the trial court's order. As the reviewing court, we make no findings of fact as to how this impropriety occurred, observing only that the order purports to have been prepared by the attorney for the husband. And that's not uncommon. When someone comes into court, they'll prepare an order and say, Your Honor, we want you to enter this order. Judge doesn't have to, but if the order says what the judge wants to say, the judge will often enter it and sign it and so on. So we further note that the attorney had cited the 2 fictitious cases that made it into the trial court's order in husband's response to the petition to reopen. And she cited additional fake cases both in that response and in the brief filed in this court. As noted above, the irregularities in these filings suggest they were drafted using generative AI. Chief Justice John Roberts of SCOTUS warned that any use of AI requires caution and humility. He specifically noted that commonly used AI applications can be prone to hallucination, which causes lawyers using those programs to submit briefs with citations to non-existent cases. Although the present case may be the first occasion for a Georgia appellate court to confront the problems that can flow from this, other courts have commented on the issue, including in federal cases. Indeed, many harms flow from the submission of fake opinions. The opposing party wastes time and money in exposing it. The court's time is taken from other important endeavors. The client may be deprived of arguments based on authentic precedent. There is potential harm to the reputation of judges and courts whose names are falsely invoked as authors of bogus opinions, and to the reputation of a party attributed to fictional conduct. It promotes cynicism about the legal profession and the American judicial system, and a future litigant may be tempted to defy a judicial ruling by disingenuously claiming doubt about its authenticity. And so it goes on and on. But the scary part...
Wait, that wasn't the scary part?
Here is that at one point in time, the court writes, well, first of all, the court vacates the order, sends it back down, and says, straighten this mess out. But there's an appendix to the opinion. The following is a list of fictitious cases included in Appellee's brief. And there's 1, 2, 3, 4, 5, 6, 7 of them. These are fictitious cases. In the interest of JMB, from 2009, I remember that one. Miller versus State, Brown versus State, Brown versus State, Walker versus Georgia, Ramos versus Ramos. That sounds like it could have been a divorce case. McRae versus McRae, and Johnson versus Johnson. That was a barn burner. Appellee's brief also contained 4 citations to real cases that have nothing to do.
He's like a rapper, dude. I love this guy.
With the propositions for which they are used. And it cites those 4 cases. And then, as noted previously, the attorney for the wife actually said, we should get our attorney fees for this because we shouldn't respond to this kind of silly nonsense.
Okay, so what the SCOTUS dude was trying to say is like, oh, I warned people about doing this and the AI and whatnot. It's not artificial intelligence. It's suggestive. It's suggestive. Okay, so look.
On that, and whether it could be narrowed in a way that would make it constitutional.
So, to your question, Your Honor, harassment is conduct, not speech. I have copies of Arizona Court of Appeals cases, State v. Brown from 2004 and State v. Snyder from 2024, further explaining that if the court would like to review those. I'm not asking the court to restrict Mr. Myers' speech on political matters or general topics, but Mr. Myers has...
Remember what Leto just said right here.
They have nothing to do with the propositions for which they are used.
State v. Brown from 2004 it would sink their case completely. So a dude was trying to get back with his ex-girlfriend and was making phone calls, but the phone calls he was saying was innocent, but the court said because of the conviction, the jury trial conviction that he had against her, that it's a joke to even think that. But here's the thing. Look at the first thing, or first footnote anyways. It says the propriety of the injunction against harassment issued by the city court is not at issue here. Okay, so think about that. Nothing else in the case makes sense except this one footnote telling the judge reading it, hey, nobody's going to look at what you do, bro. The propriety is not at issue. And also may bias the judge because he might think that there's a prior conviction that Myers has against her. You know what I'm saying? So, I don't know. Suggestive, right? And then, so the next one, and I would like to point out that one of the judges on this case, Howard Fell, was also the one honoring the bench in Lane Myers' 1454 case where they said that the defendant was indicted on direct indictment and requested summons with booking. This was not appropriate as the defendant was in custody and being held without bond. The state should not have done that. One case that says you aren't going to have any of this be reviewed by anybody because it's not going to be at issue. And then the only other one they cited is one that's not for official publication under Arizona Rule of Supreme Court, blah, blah, blah. The decision is not precedential and may be cited only as authorized by rule, wherein they cite it, and basically it says that it is not too far off in left field to think that maybe at some point, sometime, there might be a way to charge somebody for using social media to get other people to call officials and annoy them. It could be a thing that could possibly happen, maybe, possibly, in the future, if you get the right people, right? So, that's basically, so they've cited 2 cases, one that says that what you do here is not going to be looked at, and then another one that says this, what we're claiming Lane Myers is guilty of is a possibility in the future. Basically, a court has said, even though you're not allowed to cite it, right? So it's suggestive, you know what I mean? They can claim AI all they want and say, oh, we made a mistake or whatever, but even when she opens and she says, I'm not trying to restrict Mr. Myers' speech on general topics and political whatevers, nipping the actual case law, LaFar versus Cahill, that he's going to use in the bud And I actually found a better one. That's neither here nor there. We'll talk about that later. But it's suggestive, dude, and that's what. And so I don't think it was a mistake, right? And even when he said he's all well, they did mention making phone calls, so you know what I mean. Like that's all he could say about it. Here's the one that I think is more on point, but whatever. Back to the thing. You remember when the judge claimed that Lane Myers had harassing eyes, that he was staring at him? Same thing in this case, bro. Oh, and then knocking on the neighbors' doors. Same thing in this case, too. Crazy, right?
The court's like, what are you talking?
Is prosecuting is a defendant, like currently. I'm just going to play one from my previous recordings. Yeah, the whole May thing. Oh my God. Sorry, I get a little heated. Mandatory, right? When you have two options and you can only pick one of them, you shall not pick the other one and you shall do the one you pick, right? So really it's two shalls, not just one. It's mandatory, period.
It's not shall, it's may. And that's very different. And I think if there were some material circumstances that would warrant a no bond hearing, that could potentially happen.
He's doing it again, dude, because, dude, she's not dumb. She knows the rules inside and out, and she knows that this is a common way or a common mistake people make when trying to interpret it, because it is kind of a complicated way that they wrote it. But there will be no material circumstances that warrants whatever, right? And she's like, oh, I think if there were, then that might happen. No, there's no material circumstances, because the circumstances are in the rule, and that is if you write a motion, or if you don't, if the state just wants to do it. I mean, if the court wants to do it, there is no material thing that's going to do unless there is a different finding of evidence or whatever. But that's up to her, and that's not going to happen. Obviously, she knows that. So there's literally no material thing that could possibly make it happen, even though it can happen, unless you write a motion, right? In which case, it's mandatory. You may. Okay, I know I sound crazy. Let me just explain may, right? Because she said may, it's not may, it's not shall, it's may, right? Okay, let me start there. Okay, so may and shall are both group members of a group that are adverbs, I guess. Anyways, there's past, present, and future. And luckily for you guys, I memorized them all when I was like 7. This is mostly for retard Rachel, but here you go, you retard. So there's is, am, are, was, were, be, being, been, has, have, had, do, did, does, shall, will, should, would, may, might, must, can, could. Now, the ones that are important are may, might, must, can, and could. Well, shall, will, should, would. Okay. You're going to hate this, but may and shall are the same. Kind of. So, it's like you shall suck my ball. Okay, I'm trying to turn over a new leaf, so I'll cut that part out, but you get the idea. And that was just talking to slow-mo Rachel. So now we can move on to win at trial, but still be a loser because you cheated. But you also may lose at trial because you're a loser and you cheated, right? So no matter what, you shall be a loser because you cheated. You see what I'm saying? The jury may return a verdict of guilty or not guilty, but you shall be a loser and a liar either way. Now, this is for the rest of us that can cognitively use our brains to not cheat and put people in jail. If you replace, it's just like math. If you replace X or you have an equation that has the answer and you replace the answer with a different number, then the equation should not work out, right? So you can do the same thing in verb tenses or adverb tenses with English. So, for example, the sentence is this: generally, on motion or on its own, a court may re-examine bail eligibility or the conditions of release if the case is transferred to a different court, comma, if a motion alleges the existence of material facts not previously presented to the court or the defendant is unable to post bond due to the defendant's financial condition, period. The court may hold oral argument or an evidentiary hearing. So we're trying to figure out what the court's action here is to do because of certain criteria. So we start at the end. So the court may hold an oral argument or an evidentiary hearing. Those are the only two options the court has at the end of this, at the end of whatever. So those are the two options: oral argument or evidentiary hearing, one or the other. So by definition, if it may do one or it may do the other, no matter what, it shall do one of those, right? So it's not giving you the option to may not. Like, it's not saying the court may hold an oral argument or an evidentiary hearing or do nothing. It's not saying that. It's you may do one of those two, but in the end, you have to do one of those two. So there shall is implied. If you do an oral, if a court may hold the evidentiary hearing, well, if that's what they want to do because of the criteria in the sentence, previous, then that shall be done. It shall be done. You know what I mean? It's not saying you may have the oral argument or the evidentiary hearing or just choose to do nothing. That's not what may means in this sense. To back up what I just said or double check what I just said, well, you can just look at any statute, really, because if there is a may not option, it'll say may not. So according to the rule, inaction is not an option. So the two options you do have, though, are the court can re-examine bail eligibility or the conditions of release. So I'm going to signify those by these words. Now, if it brings a whole new dimension to this whole thing. So these two things can happen if the case is transferred to a different court, if a motion alleges the existence of material facts not previously presented to the court, or if the defendant is unable to post bond due to the defendant's financial condition. So basically, if you go to a new court, you get some new evidence, or you are broke. Bond. Okay, so here's what you're looking at. Any one of these is possible. You can examine the conditions of release if you have a transfer to a new court, or if you can't post bond, or if there's new evidence. You know what I mean? Release can be any one of those, right? And then same thing with eligibility. You can re-examine eligibility if you can't make the bond, or if you go to a new court, or if you have new evidence. Every one of those is precursor or whatever by the word if, meaning they're all options. So what dictates if that's going to or how that's going to happen, and which one is going to be the oral argument or the evidentiary hearing? Well, it's dictated by either the motion or the court, right? So if there's a motion for an evidentiary hearing to re-examine bail eligibility for whatever one of those reasons, then the court must have that evidentiary hearing. There's no other way to diagnose it or read it. You know what I mean? Because remember, the court's only two options are to hold an oral argument or an evidentiary hearing, right? And so if there's a motion to re-examine bail eligibility, you're not going to have an oral argument to decide if there's a motion for re-examination of bail eligibility, right? You're only going to have the oral arguments if it's just to discuss the conditions of release, right? So it's not saying that on a motion for re-examine of bail eligibility, you have an oral, you set a hearing for an oral argument about if you're going to get the evidence or if you're going to get the re-examination for bail eligibility, because at that oral argument, if you win, you're going to get the evidentiary hearing, which is already an option, thus giving you both, which would defeat the whole purpose of having or on there and having options, right? So if there's a motion for re-examination of bail, then you have to 100% are going to hold the evidentiary hearing. because otherwise the word or, and it just undermines the whole sentence. It just makes if you do both and you do it the way Metcalf wanted it to be done or thought that it should be done, it doesn't make any sense. The sentence is moot. All the words in the sentence become nothing. The judge could just not do it. The existence of the rule and those two sentences means that the judge can't do what he's trying to do. Like its very existence means that the judge has to follow either one of them or the other one, depending on the motion. You know what I mean? Or he can do it on his own in absence of the motion. But the existence of the words are the reason that he can't do what he wanted to do, and the very same reason that this judge, this whatever Lewinsky, should have followed what Lane said. Because so here's how we know that she knows. But first, here's the rule so you can see it. On motion or on its own. This is only two sentences. So on motion or on its own, comma, a court may re-examine bail eligibility or the conditions of release if the case is transferred to a different court, comma, if a motion alleges the existence of material facts not previously presented to the court, or the defendant is unable to post bond due to the defendant's financial condition, the court may hold an oral argument or an evidentiary hearing. So those are two sentences. I know it's confusing, but here's how we know that she knows what the deal is. Because the state, here on number 3, it says eligibility for bail. If the motion is by the state and involves a defendant previously held eligible for bail at the initial appearance, it need not allege new material facts. The court must hold a hearing on the record as soon as practicable, but no later than 7 days after the motion's filing, right? So you see how when the option is gone, it becomes a must. And even if the option is there, you must do one of them. You see what I'm saying? So there's no way that she can follow that rule and not follow the one above it or comprehend the one above it. Now, here's how we know that she followed that rule. Because remember, I've said this 400 times, but she only uses the right nomenclature when it benefits her. And in this case, for her to use that rule, she needs to. So it would benefit her to use the right nomenclature. You know what I'm saying? So remember, bond eligibility, the state's got 7 days. Look here, 3/26, and exactly 6 days later, 4/1, they have the hearing. This is the one the no bond hearing, she's calling it. So this is the one where she's presented all the evidence, right? So here's another special one. The Pima County Legal Services is all of them are the named victim. But it's not an incapacitated person, minor, or a business, right? Anyone that works at 32 North Stone. Now, speaking of those people, I came across this name, right? See, I'm real familiar with what an I rhyme is. Basically, it's like when a word looks like another word. For example, when people mispronounce a last name like mine or this one, they probably say the word Finch a lot, right? So I'm assuming that's the wife of Jim Finch, but I could be wrong. This Frisch right here is a damn media consultant for Tucson, Arizona, president of the Frisch and Associates Media Consulting. Now we know how the Bird Brain and we know how the Really Cool News Media and all these live streams are happening and how they're getting all this information like a written hand, motion from Myers in jail like the day after he wrote it, you know what I mean? Unredacted, you know what I'm saying? Now we know how they're getting it. Sorry about your wife, dude. I always thought the name Dottie was freaking cool. Anyhow, yeah, so Jim Finch, right? Or Frisch, whatever. I'm just guessing. See, the reason I figured it was something like a name error like that is because the only other Finch I could think of was Atticus Finch, and I didn't think you were the type to portray somebody who is arguably a dishonest, unethical, sexist, and inherently racist, and did nothing to change the racist status quo in Maycomb. So I was assuming you seem like a good dude, so I was assuming you weren't, alluding to that.
The relationship started, or at least my case started, due to Mr. Myers contacting Miss Walker through the court case through Tucson City Court. That started with phone calls to her office at the U of A, and then him going down to the University of Arizona to try to speak with her in person, which then led to him creating YouTube videos speaking about Miss Walker and her husband and the conduct that he didn't agree with.
I'm going to object on hearsay. I realize the purpose of this hearing, but since everybody's watching on YouTube, I'm just objecting anyways, and the court can explain why that'd be overruled.
So I will overrule. Hearsay is admissible at these proceedings. Ms. Stiles, I am going to ask you to lay some foundation as to witnesses who are going to be available at further proceedings in this trial before you go forward with that, however.
Yes. So, Detective, for this information that you gathered, how did you gather this information?
There were reports from the victim to the Tucson Police Department asking us to investigate harassment charges and later on violations of an injunction against harassment that she had filed against Mr. Myers.
And have you spoken with the victim?
I have.
And are you aware of whether she will be available to testify at trial?
She will be.